At first glance, today's docket looks like it's filled with ordinary landlord-tenant disputes. But don't let that fool you. Within just a few minutes, this courtroom transforms into something much bigger than arguments over unpaid rent or lease agreements. What you're about to witness are three very different cases that all revolve around one powerful question. When should the law be applied strictly, and when should compassion take the lead? The first case involves a military veteran who faithfully served his country for over a decade before losing his job and ultimately falling behind on his mortgage. Now he's facing the devastating reality of losing his home. The paperwork is complete, both sides have reached an agreement, and by all appearances, the case should be over in minutes. But then the judge asks one simple question about the defendant's military service, and the entire hearing takes an unexpected emotional turn. Next, the courtroom shifts to a Section 8 housing dispute where neither the landlord nor the tenant seems entirely responsible for the mess. Repairs were allegedly completed months ago, inspections were passed, and yet government paperwork appears to have stalled, leaving everyone pointing fingers while the tenant risks losing her home. Instead of rushing to judgment, the judge digs deeper, trying to determine who is actually responsible before making a decision that could change someone's life. Finally, the courtroom takes another dramatic turn when a tenant attempts to challenge an earlier judgment after months of unpaid rent continue to accumulate. Here, the judge's patience is tested as sympathy collides with legal reality. You'll see firsthand how a judge balances fairness with the obligation to enforce the law, even when the outcome is heartbreaking. Throughout these hearings, pay close attention to the judge's approach. He isn't simply deciding who wins and who loses. He's weighing personal hardship against legal responsibility, asking difficult questions, and showing viewers exactly how much discretion judges sometimes have, and where that discretion reaches its limits. By the end of today's video, you'll witness compassion, frustration, accountability, and a decision that leaves no doubt about where the court ultimately draws the line. The question is, if you were wearing the robe, would you have ruled the same way? Let's step inside the courtroom.
Your Honor, this was the Secretary of Veterans Affairs bought this property at a foreclosure sale. Mr. Reddick is a occupant of the property. We have come to an agreement that he will vacate the property and relinquish possession of the property to the Office of the Secretary of Veterans Affairs by the 15th of June. And we've signed a consent judgment to that effect.
Is that correct, Mr. Rick?
Yes, sir.
You're a veteran, sir?
Yes, I am, sir.
What branch?
United States Air Force.
God bless you.
Thank you, sir.
How long were you?
13 years.
All right. And what, you fell behind and
I lost my job, and there was no way of me without having a job because I'm supply chain management. So I had a very good job, and I haven't been able to find a job to replace that level of income. And that's the reason why I fell behind.
on the 15th, what are you going to do?
15th, I'll be out.
Going.
I'm going to put all of my stuff into a storage, and I'm going to figure out where I'm going to stay then. That's my immediate plan. I mean, I do have sons and daughters here, so push come to shove, I could probably stay with them. For right now, the plan is to, I'm seeking, obviously, an eviction doesn't help, you know, so seeking a rental apartment or anything like that with my credit, et cetera, that's a challenge. I've tried not to have to rely on the Veterans Administration to help me further. I don't plan on.
But you earned it.
I did, but
You earned it. You don't have to apologize to anybody. You earned it.
thank you, sir.
This is already becoming far more emotional than a typical eviction hearing. The judge has learned that the defendant served 13 years in the United States Air Force, and instead of immediately focusing on the legal paperwork, he pauses to acknowledge that service. That's significant because it reminds everyone in the courtroom that behind every case file is a real person with a unique story. The veteran explains that he didn't intentionally stop paying his mortgage. He lost a well-paying job in supply chain management and simply couldn't replace that level of income. That's an unfortunate reality many families experience after an unexpected job loss. The foreclosure process doesn't necessarily distinguish between someone who refuses to pay and someone who genuinely cannot. One moment that stands out is when the veteran says he doesn't want to rely on Veterans Administration assistance. The judge immediately pushes back, reminding him that those benefits aren't charity, they're benefits he earned through years of military service. It's a powerful reminder that accepting help you've earned is not something anyone should feel ashamed of. As this conversation continues, you can already sense the judge wrestling with something beyond the legal paperwork. He's asking himself not just what the law allows, but what justice truly requires under these circumstances. What would you do if you were in his position?
You know, I sit here and I just know I get to do what I get to do because people like you did what you did. I'm reminded of that every day. And I realize they have to do it. I'm not blaming counsel, but when our veterans fall on hard times, all of a sudden what we do is we just kick them to the curb. And you just don't know what you're going to do. You're saying you're going to get your stuff into storage, but you're not sure where you're going.
Right, sir.
Not happening, not today. Because I'm not going to enter the judgment. I'm going to adjourn it out, let him sort out, get your stuff into storage, figure out where you're going. All right. I'm going to give you that chance. All right. Because I can't do it. I mean, if I have to, I will, but I should under these circumstances.
I'm trying to cooperate, but
No, I get it. You don't have to apologize for a darn thing. All right. If somebody over the objection of plaintiff, I'm gonna adjourn this to June 12th, 2026 at what time? At 1 p.m. and let you try to get a better plan together for yourself, see where you're going. Okay. I can't give you everything, but at least for your service, I owe you that.
thank you, sir.
That decision probably surprised quite a few people watching. Even though both parties had already reached an agreement, the judge refused to enter the consent judgment immediately. Instead, he chose to adjourn the case and give the veteran additional time to organize his belongings and develop a realistic housing plan. Now, it's important to understand what happened here. The judge didn't erase the foreclosure or cancel the agreement. He simply exercised judicial discretion to slow the process down, recognizing that forcing someone into immediate homelessness serves very little purpose when a brief delay may allow them to transition more safely. Notice how carefully he explains his reasoning. He openly acknowledges the legal rights of the property owner while also recognizing the sacrifices made by someone who served the country. That balance between compassion and the rule of law is something judges face every day. It's also worth mentioning that this isn't favoritism. Judges cannot ignore the law simply because they feel sympathy for someone. But where the law allows flexibility, many judges will consider extraordinary personal circumstances. Do you think this was the right call, or should the agreement have been enforced immediately since both parties had already signed it?
All right. We'll see you on the 12th, Mr. Ray.
Thank you.
Thank you. Thank you.
Have a good day, sir.
Thank you. You do the same. Babu Banda Pade. No, I'm messing it up. Versus Dayet Connor. Your name?
Yeah, Kyle.
Where are we on this case? Termination?
Correct. So background story here is 9 months without rent.
Does she currently have a lease?
Currently, she no. This is through section 8 and it's
Pardon?
through section 8 and they terminated their lease.
What's your position on this?
So that's why I asked for the 2 weeks adjournment, so I can finish the other one, because he knew he was in abatement. I didn't know he was in abatement. Was
What?
in abatement. With section 8, he was in abatement. He knew that. I did.
Abatement for what reason?
That was withholding his rent. I don't know. It was between them two.
Why was the rent being abated?
Originally, the rent wasn't being abated because they said the house wasn't repaired.
Yeah,
And we passed even the city inspections. You know,
did you go back to section 8 then?
we tried to call, nobody would answer.
Then that's not her fault. The apartment unit goes into abatement
Correct.
because of repairs you failed to make. So they don't pay rent.
Oh, sorry, the repair was done almost 9 months ago. We've been trying to contact them. And the city has been out there, re-inspected the house.
So about time this
Hold on. Who administers the section 8 that you got this through?
RPI.
That's the problem.
Listen, so when the city came out, that was of February of this year, right? So section 8 told me when I talked to them in March, when he said he was going to evict me in May, when I talked to them, they told me, well, this is called retaliatory eviction. They told me to come here and let y'all know that this is what's going on, ask for another adjournment, because they're like, they said this, he knows what's going on, I don't. So then I spoke with them in March, because they said, don't worry about it, we're handling it. So then I spoke with legal aid, because remember I came down last week, I spoke with legal aid, they're trying to help me with the whole section 8 problem because of him. So they said, see if I can get adjournment till after the 2nd, because that's when they go in and talk to section 8.
They're going in on June 2nd to talk section.
Yes.
Got it.
But Your Honor, just a couple things here to clarify. I have not gotten any communication from any regarding.
Yes, he did, Your Honor. I can
Stop. Go ahead. What were you saying?
So far, I've not gotten any communication from anybody. Are saying that, what are we doing next steps? In fact, even beyond that, we have had ordinance.
Here's my problem. I'm just going to stop both of you, because here's my problem. If the initial basis of not receiving rent was an abatement for repairs, and then that subsequently that rent has not been turned on, that's not generally, if ever, the tenant's fault. It's something else. So I'm not punishing her because either you didn't do the repairs, but you're telling me you did, or that RPI won't do what they're supposed to do. I'm not doing that.
Now the courtroom shifts into a completely different type of housing dispute, and unlike the previous case, this one isn't nearly as straightforward. The central issue here isn't simply unpaid rent, it's whether the tenant should be blamed for a breakdown involving the Section 8 housing process. Here's what's happening. The landlord argues that repairs were completed months ago and that city inspections were passed. Yet according to both the tenant and the judge's understanding of the situation, the housing authority apparently hasn't resumed rental payments. If that's true, then the tenant may be caught in the middle of a bureaucratic problem she didn't create. The judge makes an important observation here. If the rent stopped because repairs hadn't been completed initially, but the landlord later fixed everything, then the next step depends on the housing authority processing the case correctly. If that administrative process stalls, it's difficult to hold the tenant entirely responsible for something outside her control. Instead of rushing toward eviction, the judge pauses the case and gives everyone more time to resolve the Section 8 issue. It's a reminder that sometimes the biggest obstacle in court isn't the people involved, it's the system itself.
Well, here's the problem right now is that they've gone on for 9 months. I have no.
Pardon?
Gone on for 9 months. I have nobody to talk to at RPI, no contact.
So you kick her out.
It's beyond that now. It's basically right now, there's that. There's the whole idea of the ordinance officers going out there. I'm in court. I had to pay $350 a couple months ago because of the house was in bad shape outside because of trash and the like. And then on top of that, we also have to mow the lawn, do everything, take care of the property, so that way she can live there.
Not
We're not
true.
getting any rent or anything for any.
But
Not
you
true.
wouldn't get the rent because there weren't repairs. That's where this starts.
Mhm.
Then you do the repairs, you get the inspection, and I'm going by what you're telling me,
Exactly.
and RPI doesn't turn it back on.
But then what do I do at this point? Because we've done
You need to
the,
talk to RPI.
nobody's calling me back from market. Who do I contact at RPI? I've been trying to reach them for months. Nobody's answering the phone, nobody's returning call.
Legal Services is meeting with them. They told you on the 2nd.
Yes.
This matter is adjourned 2026. What time? 1 p.m.
I'll be in. Thank you.
Good afternoon, Your Honor, Andrew Kane. Corey Anderson.
All right, where are we on this?
First and foremost, I would like to state
Hold
that
on a second. Why do I have this case? Because
what I've done, 5%.
which one? All right. Go ahead. What do you want to say?
I was gonna say that she has been using my personal information to impersonate me. And she's still harassing me. But apparently, the neighbors have been telling me that as well.
The courtroom has now shifted to its third major case, and this one immediately feels different from the previous two. Unlike the veteran who admitted his financial hardship or the Section 8 tenant caught in administrative confusion, this hearing centers on a judgment that has already been entered by the court. That distinction is critical because the judge is no longer deciding whether money is owed, he's deciding whether there's any legal reason to delay enforcing an existing judgment. The tenant begins raising concerns about repairs, accounting errors, and even allegations of harassment. Those may be genuine concerns, but notice how the judge redirects the conversation. His focus is much narrower. The question before the court isn't whether every disagreement between the landlord and tenant has been resolved. It's whether the existing judgment remains valid and whether the tenant has complied with it. This is an important lesson in courtroom procedure. Many people walk into court wanting to tell the entire history of a dispute, but judges often have to keep everyone focused on the specific legal issue that's actually before them. Even legitimate complaints have to be raised through the proper legal channels and at the appropriate stage of the case. Do you think the tenant is trying to revisit issues that should have been addressed earlier, or is she simply struggling to understand where the legal process currently stands?
I'm here on a writ hearing.
Your Honor, from plaintiff's perspective, if I may, this is a writ hearing. We are coming up on the 56-day time hearing issue. As of our last hearing, we acknowledged that the defendant had made a $7,600 payment towards the rent that was owed when this case was filed, leaving a balance on that particular judgment of $4,107.37. The court was adjourned that so that that amount could be tendered to the plaintiff. Thus far, we don't have those funds. And furthermore, Your Honor, there's currently another 3 months worth of rent due.
Are you going to pay off this judgment?
I'm sorry, what did you say?
Are you going to pay off this judgment?
I'm going to pay it, but it's not right. I would like to go over it since I do not owe that much.
Okay, ma'am.
There that I would like to look over and see something about repairs, but nothing was repaired. So I'm trying to see where the extra money is coming from. Still paying the water.
Lyman, this judgment was issued in March.
I have 6,600 to pay, but I would like to see everything before I pay it, so I just don't use.
That's the judgment. I'm not disturbing the judgment.
Well, it's not right at all, because I should only hold 1,000.
I'm not disturbing the judgment. Judgment is what it is. I don't have anything filed indicating that I should even look at that judgment. That's what the judgment was issued for. I'm now in May. If you pay off the judgment, they got to figure out what they're going to do.
So I emailed the court the day of with that, saying it wasn't right.
All right, let me just be clear. I'm not doing anything with the judgment. You can keep talking to me about it if you want, but I'm going to tell you the same thing.
This is the turning point of the hearing. The judge has now explained, more than once, that the previous judgment isn't being reopened today. In other words, the court isn't reconsidering whether the amount was fair or whether it should have been calculated differently. That decision has already been made, and unless there's a proper legal basis to challenge it, the court must treat it as final. Notice the judge's patience throughout this exchange. He repeatedly gives the tenant opportunities to explain her financial situation, asks when payment can realistically be made, and even tries to clarify what funds she actually has available. He's not dismissing her concerns outright. He's trying to determine whether there is any practical path towards satisfying the judgment before the eviction process moves forward. At the same time, the landlord continues to point out an unavoidable reality. Every month that passes without payment increases the amount owed. That's why the judge begins talking about time rather than just dollars. Delaying the case again doesn't solve the underlying problem if the unpaid balance continues growing. The longer the case drags on, the more difficult it becomes for either side to find a workable resolution. If you were the judge, how many extensions would you consider reasonable before deciding enough is enough?
So your choices are you either pay off the judgment or I just deny this and they're going to go forth and do what they got to do. So which do you want to do? There is, you said 4107
37 on
on the judgment.
the judgment.
You said 37 or 40?
$4,107.37.
Okay. I think we were starting at the wrong one. All right. Are you going to pay that off? When are you going to do that?
66 that I can turn in next week.
Well, I can't. Lyman, I thought you said you had 66. Do you have?
I've been in the hospital.
Okay, I got that. I understand, and that's why I adjourned the proceedings out. But there's about 4,000 that's owed on the judgment. When is that going to be paid? Because the writ, Ms. Lyman, understand, the writ is sitting here in front of me right now. When is it going to be paid? Because I'm assuming if you pay that next week, and if I remember the rental rate, it's about 3,300 or something like that, it's going to go up again. They're just going to begin the case again. I mean, but that's not where I am right now. What day next week are you going to pay this?
Say,
I can't. That's not even next week. That's the week after.
why haven't you surveyed?
And at that point, they're going to be 4 months, right? Is that right, counsel?
That is correct, Your Honor.
So then I'm going to be what, 12 plus, well, I'm going to be about 13,000 behind at that point. Simon, I can't continue to do that. I don't mind giving people an opportunity to pay and catch up, but I can't do it. So, you know, the way it works is that I'm signing the writ, I'm issuing the writ, I'm denying the motion to.
And here comes the decision that many viewers probably saw coming, even if they hoped for a different outcome. The judge signs the writ and denies the request to further delay the eviction. But pay attention to the reasoning behind his decision because it's more balanced than it may first appear. Throughout the hearing, the judge demonstrated compassion in all 3 cases. He gave the veteran extra time because he believed the circumstances justified it. He postponed the Section 8 dispute because unresolved administrative issues deserved further investigation. But in this final case, he reaches a different conclusion because the legal process has already provided multiple opportunities to resolve the debt, and the unpaid balance continues to grow. Even now, the judge leaves one final window open. He explains that if the outstanding judgment is paid before the writ is executed, the situation may still change. That isn't the same as canceling the eviction, it simply reflects how eviction procedures often work in practice. The court is enforcing the law while still recognizing that payment before execution could alter what happens next. This moment highlights one of the hardest parts of judging. Compassion matters, but it cannot replace legal obligations indefinitely. Eventually, every judge reaches a point where fairness to one party must also include fairness to the other.
Stay the eviction, or I'm not staying the eviction. The writ is signed. If you pay it prior to the execution of the writ, then fine, but otherwise I'm not doing anything else. I can't, in good conscience, do that. So, thank you. Ann's gonna need that.
Today's courtroom session offered 3 very different housing disputes, yet each one revolved around the same fundamental question. How should the law respond when people face genuine hardship? In the first case, a military veteran who lost his job after years of honorable service faced foreclosure despite reaching an agreement to leave the property. Rather than immediately entering judgment, the judge exercised discretion by granting additional time so the veteran could secure storage for his belongings and work toward a more stable plan. It was a powerful reminder that compassion can exist alongside the law when circumstances allow. The second case involved a complicated Section 8 dispute where questions remained about repairs, inspections, and administrative delays. Instead of blaming either party before those issues were fully resolved, the judge chose to adjourn the matter, recognizing that the tenant should not necessarily bear the consequences of a bureaucratic breakdown that may have been outside her control. Finally, the third hearing demonstrated the limits of judicial flexibility. Despite listening carefully to the tenant's concerns and giving multiple opportunities to discuss payment, the judge concluded that an existing judgment could not be ignored indefinitely. With unpaid rent continuing to accumulate, he denied the request for another stay and signed the writ, while still acknowledging that payment before execution could affect the outcome. Taken together, these cases show that judges don't simply choose between kindness and the law, they constantly work to balance both. Sometimes that balance results in another chance. Other times, it means enforcing difficult legal consequences that cannot be delayed any longer. If you found these courtroom moments as thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns, legal analysis, and unforgettable judicial moments. We'd also love to hear from you. Which of these 3 rulings do you think was the most fair, and would you have decided any of them differently?